Got it. Okay, so let's go back to our case. So this is the case, which is quite a popular, typical situation that someone wants to start a business cooperation with a Chinese company and is kind of a newbie to this area of doing business with China. There might be various options of what type of business would be done when interacting with China. So here you can see your client would be interested in selling its products in China, buying some products from China, and possibly in the future having a larger framework to work together with a Guangzhou Chinese company here to develop a newer model. Likely they would like to establish a company together, or there could be any other way of working together and cooperating. So these are very common scenarios. So, these are also the scenarios that I've seen a lot when working in the law firm, but in China, that we were having European clients that indeed were trying to establish the business relationship with the Chinese clients, usually coming to China. And therefore, we were asked about the advice on a whole range of issues that potentially can arise in this context. And what kind of issues can arise in this context? Many. So first of all, the question is, who am I dealing with? Who is my business partner? Should I trust this person? Should I trust this company? Is it having a long history of operating? Is it a new subject? Are they having international experience? So this is number one thing. Your understanding who is your potential business partner. And for that, you oftentimes will need to get sufficient information to know how trusted the company can be in your dealing with that company. Second question that commonly arises in this context is also, okay, given the fact that I will be dealing with a Chinese company, there is quite some likelihood that there will come Chinese law related issues, right? How to understand the Chinese law, how to apply the Chinese law, what is even the ranking of sources, right? What is the value of the documents produced by the Chinese Supreme People's Court? These are all very detailed questions, but navigating how the law as a legal system in China works, what's the priority of sources of law, which potentially can be legal basis in the issues that you have to address. This is another challenging issue. Number three, very practical, how to negotiate. Oftentimes, if we would go back to our case, the question will be, first of all, negotiating the contract conditions. You know that this is very practical, that the parties meet and they have the different goals that they wish to achieve, and somehow they have to reach a middle ground and decide on common vision of this contract. So when I say how to negotiate, this question might seem simple, but if we look back into the last point on the slide, that has to do infrequently with cultural differences that are extremely important in the context of China, cultural issues. We will talk a little bit more about that. Then if we would especially look at this third example that I gave you here, that in the future, your Spanish client and the Chinese company would like to, for instance, establish a company and work together, the question is here, what form of cooperation to take, right? What kind of options are we having? Can I, as a Spanish, open a company in China in certain sector? So to give you a rough background, China is having a certain division of the industries in which foreigners can access, and there is a number of industries in which foreigners cannot participate actively. So there you will be having another question, okay, can I even act in a certain industry as a foreigner? And if I can, what kind of cooperation models do I have? Meaning, for instance, can I open a company myself? Do I need a Chinese partner? These are oftentimes very practical issues that arise in the context of especially cooperation between a foreign company and a Chinese company. Now, if you're having a scenario where the contract will be needed, how to draft such a contract? Oftentimes there will be a request, okay, let's have dual version. Let's have, for instance, Chinese version and a Spanish version, right? How do we do that? How do we make sure that we understand the versions, which version prevails? You know that this is a good practice. If you have dual language contract, that there is one binding right, language version, and the other obviously can be there for the purpose of reference for the other party. Another possible question, how to protect my IP rights. So imagine again that our client is wanting to sell some of its goods in China. These are, let's assume, goods with high reputation already. So when entering the Chinese market, you might be having justified concerns. Okay, what's going to happen, for instance, to my trademark? Am I going to see in 3 months, in 2 months, some fake goods, some fake mining equipment that uses my trademark? That's possible as well, right? So protecting of intellectual property rights is another legal issue that can arise in the context when foreign companies deal with Chinese companies. Now, another issue, what to do when something goes wrong. And that means when we have a dispute, when the parties disagree. And you know that in business disputes are common, and therefore this topic is not really something to neglect. And finally, and I already mentioned that, how to navigate all of the cultural issues, especially when it comes to the communication. Again, I would like you to think about Chinese legal system as obviously the law, but not only the law on paper, but law functioning in a certain dimension, meaning in connection with the culture, in connection with certain communication style, and so on and so forth. So as you can see, it's quite a headache. That's why I put this little boy as an illustration. It's most likely a Chinese boy, as we can see. But these are some of the issues only that generally can arise just in the context of one client, in the context of this case scenario that I wanted to present to you. So obviously, I will not be able to address all of the issues today in this short lecture, but let's focus on the disputes. Generally,
Monika,
yes.
May I ask you a question?
Sure.
Okay. Can you put example where you find that cultural shock when you were like a lawyer there in China? So
sure. So look, culture is a whole separate area that I think it's worth attention. It's not even, Paula, the shock, but these are oftentimes more subtle differences, because as you guys can imagine, young Chinese, they get educated abroad. They also have the exposure to foreigners, but still, in my view, they have this very strong Chinese core. So one specific example, Paula, would be lack of direct communication. That, you know, we communicate very directly. If you want the feedback is directly given. But Chinese communication, oftentimes when there is a problem, results, this kind of preservation, this kind of not wanting to offend anybody, result in the issues that, for instance, someone is not raising the problems to you until they totally explode, right? So it's a more preserved style of communicating, not very direct. I would say it's really opposite to what we are used to communicate like. So for instance, Paula, you asked the question immediately. I want to know the answer, right? I feel very much interested in that. In China, most likely the students would wait until the end. I'm not saying that any of the styles is better or worse, but it's different. And that's the difference that you want to be aware of. So certainly, flagging to you, mentioning to you the problems, this is something different. Communication of the problems, generally direct communication, direct disagreement. Sometimes, for instance, when you negotiate with the other party, it oftentimes looks so that, you know, let's say foreigners, they speak a lot. Chinese are sitting there, not saying much. You get the impression that, oh yeah, they agree to everything. And then you get an email, you know, a day later that none of the conditions are acceptable to us. So certainly this more reserved, cold communication, not direct. I think this is the major issue. This is the major misunderstanding. Let me put it that way. So I always encourage my students to invest into understanding Chinese culture, into understanding the Chinese culture, for the sake of understanding also how the law functions. Because if you would be, for instance, comparing Spanish civil code and let's say Chinese civil code, on paper, oftentimes they will look very similar. You might be having an impression that, well, you know, we also have this provision. But the question then moves into how, number one, the law is being applied, two, how the law is being enforced. right? So this would be the differences, and therefore this cultural awareness is very, very important. Now, if you sometimes, Paula, another example, if you communicate very directly, for instance, disagreeing, and especially with someone more senior, this is being perceived as quite offensive. So for instance, when I work with China U School of Law, one of my bosses is Portuguese actually, and the other is Chinese. And I know I can directly go and talk to my Portuguese boss, for instance, communicating my disagreement and some criticism. Obviously, I'm also trying to be constructive, but I know that it's much more distance when it comes to communicating with my Chinese colleagues, and especially with more senior colleagues. I think, guys, you might be familiar with the concept of losing face, that if you are criticizing somebody, face is a very important concept in China, extremely important to keep the face. We also have the saying, like in the Western culture, to lose the face, right? Oh my God, I lost my face. I completely said nonsense in my class. I'm not credible for my students anymore. But this concept is even more important, crucially more important in China, where it is really important that you save your face, that no one is undermining your authority. And to Paula, give you an example, if you have a Chinese professor, oftentimes, if the students even can see that the Chinese professor is not saying the correct thing, because let's assume the law has been already revised, right? And everybody knows there was a revision and the professor goes on discussing old provisions, Chinese students will not rather comment on it. They will like, okay, think internally, he's not correct. I just have to make sure that I apply the newest law. But they will not raise hand and say, I think you applied the wrong law, professor, because that would be perceived as losing face. Face is of tremendous value in China, and therefore, especially criticism and direct communication are much less present in the Chinese culture. So communication style, reading from the totality of behaviors and not only from silence. Silence doesn't really mean much in China. Silence can go in completely two directions. I had this experience that we were at the negotiations and I thought like, we got everything we wanted. I didn't know it would be that easy. And then exactly the next day, we got a draft by the Chinese party saying, very kind and polite, thank you very much for a very interesting meeting. However, we would like to point out that this point is not even saying not acceptable to us, but will be further subject to the discussion. So really, like trying not to be direct and not to offend somebody will be of very, very, very big importance. We could talk about just culture for hours, but let's move on a little bit back to law with your permission, if Paula, that answers your question. Yeah?
I will have another one, but go on.
Yeah. Okay. Let's see what else we will have from other participants, and let's try to speed up a little bit, and then let's see. We will be having good time, a good amount of time for questions. So, guys, straight to the disputes. General observations is this: better safe than sorry. Think about potential problems ahead. That's why you have instruments such as due diligence. I think the term is familiar to you. Due diligence, it means that you are supposed to investigate the issues up front. So for instance, in case of this first question, who am I dealing with? Who is my business partner from China? You can check it. You can check the registry documents of that party. You can check what kind of capital this company is having, what kind of dealing history, previous transactions it is having. But most likely for conducting such a screening of your potential business partner, you will be needing some professional assistance in China, right? Number of things, number of solutions will also obviously depend on bargaining power, what kind of negotiating strength in a certain relationship you have as a foreign company. And again, I could not stress it more, be mindful of cultural differences also, or I should say in particular when it comes to communication. If you don't hear about the problems, it does not mean that the problems do not exist, right? So to give you another example, just last week I was preparing a lecture for my Chinese students, and it's obviously subject to approvals in China. And I was asked to make slight modifications. which I understand that they are not supposed to be that slight, but it's a cultural, it's a kind of very polite way of communicating. We want you to change the things, right? So this is something we need to be aware of. But straight away to disputes. So imagine I have further question building on our case circumstances. So imagine that your client from Barcelona, Good Mining, eventually had a contract with Guangzhou XLM, right? Under this contract, the Chinese party was supposed to deliver to your client 10,000 drills of certain models. Yes, like big drills. You remember our company is dealing with the mining equipment. The drills have arrived in Barcelona, but well, your client investigates these drills and they are very poor quality. So obviously your client takes the phone and calls Guangzhou XLM, but they say like, look, to us, they are fine. This is exactly what you wanted. This is exactly what we had in the contract. I'm sorry, everything is good on our end. Now, obviously your client isn't happy and asks you for advice. So here we assume that we already have a contract between these two parties, right? Again, a very common scenario when it comes to the Chinese foreign business. There is a contract, goods are arriving, goods are of quality lower than expected or lower than agreed. Now, what can you do? So you have a dispute, right? You certainly have a dispute, you have this contract, and the contract does not mention usually anything about dispute resolution. And here, that's why I want to push your attention a little bit to what I just said. Better safe than sorry. Think ahead about possible problems. So when I want to focus you on dispute resolution in the context of China foreign disputes, first of all, I want to give you this parallel. Normally, when people get married, right, they don't discuss like, wait a second, let's agree how we should divorce in case of problems. That does not happen in life, right? But it makes sense to do that in business. Why? Because where there is business, where there is money involved, usually there are problems, right? So you want to know in advance, okay, how am I going to solve my problems? Now, very briefly about the disputes. You are having different types of disputes. You might be having the disputes between two states. We are not going to look at that. You might be having so-called investment disputes, where on the one hand, you have a private investor, let's say a Spanish investor, who wants to build a highway, who got hired, who got the contract, won a bid, and is supposed to build a highway somewhere in the south of China. So on the one hand, you will have a pick whichever you like, the big Spanish company in charge of construction, and on the other hand, you would have Chinese state as a contracting party here, right? So there can be disputes here. So to give you a real case example, there was a massive dispute in Poland where the scenario was the opposite. The Chinese company Kowek won a bid to build a highway in Poland. And that was shortly before 2012, when Poland was hosting Euro Cup, right? Big deal, whole Europe is traveling to Poland to watch the football games and things like that. And the problem was that Chinese investor miscalculated the prices and therefore was not able to finish the construction on time, which was very essential, because not finishing the highway on time meant for all of the foreigners traveling to Poland to watch the football games having troubles actually to get there, right? So there is another category of disputes, which are the so-called investor-state disputes. Now, most common disputes, like our case, is when you have a private party going against private party. So like, company from Barcelona against company in Guangzhou. Important thing is that we are having different ways of resolving different disputes. And, we generally can choose, but the question will be obviously whether you can choose in a given moment. Because if we go back to our case, look, there is already a dispute between Good Mining and Guangzhou XLM, right? So you already know that there is a tension, there is a misunderstanding. Those who have classes on private international law, you already know that there is somewhere a default answer which court should have jurisdiction, right? It might be beneficial to one of the parties. Very likely in this situation, it might be Chinese court, or, you know, in different instances, it could be Spanish court. Regardless, already there is some court that would have jurisdiction, and the other party simply might not be willing to change that. So when I pose you this question, what are different ways of resolving the disputes that you can choose from? The question is here, when can you choose? And certainly choosing something when there is already a dispute is much more difficult, because the parties, number one, are already having a dispute and it's difficult to talk. And number two, there already is some solution, meaning going to certain courts, and that might be beneficial to one of the party, and that party might not be willing to change it. So this is my better safe than sorry. Think about divorce when you are getting married. So now imagine we are facing this situation that we have a dispute with a Chinese party. You feel like Kevin, you see all of the complications that, oh, wow, we might end up in front of the Chinese court, which means Chinese language, Chinese procedure. How am I filing the case? How do I submit the evidence? How do I appeal if I lose? You know, all of these issues, right? Most likely, if the dispute is in China, in front of the Chinese court, you need a Chinese lawyer. You certainly need a Chinese lawyer, because you cannot even represent your client as a foreigner in front of the Chinese court. There is an obligation that you get represented in front of the Chinese court by the Chinese lawyer. You can be super fluent in Chinese language, does not matter. Now, when it comes to, you know, disputes with cross-border dimension, you have another thing that I marked in yellow, which is enforcement. Even if you win, what do you do with the decision? We talked about it many times today and in the past. Parties want money and not a piece of paper, meaning if they are winning, they want to be able effectively implement certain court decision. So very briefly about the methods of resolving disputes that have meaning in the cross-border context. Obviously, it's litigation. We also have arbitration, which is a private way of resolving disputes. We have mediation, where you have two parties and a neutral mediator that is supposed to help the parties to work out the solution. So very briefly, to address the difference between arbitration and mediation, in arbitration, you have a decision maker. The judge in arbitration, so-called arbitrator, is making a binding decision upon the parties. In mediation, there is a neutral who is there to help the parties work out their own agreement, settlement. If the parties are unwilling to talk, no mediation agreement, no outcome really. In negotiation, you have just the parties talking to each other without the involvement of a third neutral. So I want to talk today about arbitration for a moment, and about arbitration in China in particular. Why do I want to talk about arbitration in China? You know that international arbitration can take place pretty much anywhere according to the parties' agreement. Arbitration gives the parties a lot of flexibility, a lot of power to shape the proceeding according to their needs and desires. So it could be really possible that, look, in our case where there was a contract, that one party is from Spain, one party is from China, and they neither wanted to arbitrate in China nor in Spain. They don't want to use Spanish courts, they don't want to use Chinese courts. So let's say they can say, okay, let's do that in Singapore. Let's have a neutral place, let's do it in Singapore. So in our case, it would be relevant that at the time of preparing a contract, the parties decide, for instance, okay, in case of disputes, we will go to Singaporean courts. Or they say, in case of disputes, we will go to arbitrate in Singapore. Again, obviously, you can try to reach an agreement once the dispute has arisen, but I was trying to make it clear for you that when the dispute is already existing, it's much more difficult to reach any agreement. So let's go back to the question of arbitration. Why oftentimes, if you think about disputes like between Spanish and Chinese parties, we end up arbitrating in China, is because number one, Chinese parties oftentimes they have quite strong bargaining power. Number two, arbitration is international in that sense. So you can it's not like in front of the Chinese court. You can choose a foreign arbitrator. You will have the proceeding in English. You can appoint the arbitrator that you like. You can't go to the Chinese court and say, I don't like Judge Zheng. I would prefer judge more, right? You can't really do that. But again, precondition for arbitration to benefit from its advantages, meaning flexibility, neutrality, professionalism, because for instance, you can have as your arbitrator, let's say retired judge, but you might be having an IT person if your dispute is concerning certain IT issues. So this expertise is also some other advantage of arbitration, but the precondition for arbitration is clearly an agreement to arbitrate. You have to have a clear yes from both parties, an agreement to arbitrate. If you don't have the arbitration agreement, you cannot force the other party to arbitrate. This is different from the courts. Because if you want to sue me, right, or if you want to sue a Chinese party, the court will accept the case, right? There will be obviously a question of jurisdiction, but you don't have to have an agreement of the other party to sue this party. In order to use arbitration, this is essential to have an agreement of the parties. When it comes to these two other methods, mediation and negotiation, obviously, you have to have the willingness of parties to talk and overcome the obstacles. If we don't have that, it's not going to work either. But again, about arbitration, I want to start with one point, which is pretty much at the end of the slide, and that is enforcement. So in a moment, we'll be talking about legal basis to enforce a decision made in arbitration. We will compare it with the litigation, obviously, but to me, one of the key benefits of arbitration, whether it's arbitration in China, whether it's arbitration in Singapore or in Spain, is that if you are arbitrating against a Chinese party, then your chances to enforce the decision in case you win are very high. Why? Because of the New York Convention. Pretty much all of the commercial players in the world are the signatory states of the New York Convention that obliges the parties to enforce decisions coming from international arbitration. Again, it refers to arbitration and not international litigation. So when it comes to arbitrating in China, China has its arbitration law, which is currently in revision. China also has a number of leading centers that have handled actually already quite many international cases. Some of this I listed for you too. I pasted you the logos of two leading institutions. One of them is so-called CTAC. The other is Beijing Arbitration Commission. If you are interested in more details, I warmly encourage you to visit their websites. The websites are bilingual, so you can get a lot of information in English as well. So as I mentioned, one of the advantages would be that you could pick a foreign arbitrator. It does not have to be a Chinese arbitrator. I want to also flag the availability of Hong Kong. But here, I want to stress one thing. When it comes generally to the legal system of Hong Kong, it's different from the mainland China. It's different from PRC, right? You know that there are two separate legal systems. China calls it one country, two systems. So Hong Kong, guys, so Hong Kong is a typical common law jurisdiction. To give you an example, PRC, China, mainland, is civil law jurisdiction. So be mindful when you talk about Hong Kong law that you're talking about separate legal system. Proceedings in Chinese arbitration are actually quite efficient, fast, and comparatively cheaper than those, for instance, in France, in front of the ICC arbitration court, which is a very common court for the international disputes. And I can already tell you, you can look into the statistics. Spanish parties not infrequently are using arbitration in China. So the cases happen that the Spanish party is involved. I've been currently talking to one of my colleagues from one of the leading law firms here in Barcelona, and he's at the moment handling a case for the Spanish client in front of CTAC. And he was asking me exactly the questions about the communication. Like, look, I don't know, like, I mean, the response has not reached me. Should I write back? So this is very, very interesting. But generally, these institutions, they already have quite some international experience and exposure, and generally quite good reputation, so might be a safe bet. So I want you to imagine that not every time when you hear about dispute with a Chinese party, you have to feel like Kevin here, right? There are more international solutions, and certainly arbitration in China would be one of them. especially reasonable because you would have a good enforcement basis anywhere in the world. So look, even if you would be having this arbitration in Singapore, again, New York Convention will enable you to enforce in China. If you will have even the arbitration in Spain, if for instance, Chinese party would accept to arbitrate in Spain, again, New York Convention will allow you to enforce. So those are some of the basics. And arbitration in China is really very extensively used when it comes to international disputes, cross-border disputes. Now, if we think about another option, going to the court, so, it can be as a default principle, according to private international law rules, we might end up in front of the Chinese court, we might end up in front of the Spanish court, or we might end up in front of some other court, right? It could be also so that, for instance, the parties had this jurisdiction agreement and they decided, okay, in case of any disputes, we will, for instance, go to the courts in Switzerland. That's possible. Here, options are available, obviously, but the question is the enforcement. This is my fourth point here. And I want you to remind that in order to enforce a foreign court judgment, you need a legal basis. Those who studied EU in litigation know that Brussels I recast is exactly this enforcement basis, but things get more tricky when it goes beyond EU. So let me tell you what we have when it comes to China Spanish court judgments. Spanish judgments to be enforced in China, or the other way around, Chinese ones to be enforced in Spain. There is a special treaty between China and Spain from 1994, which obliges two countries to enforce court judgments if one of the parties is not obviously complying with that. Now, when I looked into the most current statistics, none of the cases has been reported as enforced based on this judgment. What does it mean? What does it tell us? That either the parties voluntarily comply, or that they are using arbitration to resolve the disputes, or maybe simply the case has not been reported anywhere. But generally, it's not that we are aware in the context of China and Spain of a good number of the court judgments that were enforced on based on this kind of bilateral treaty. Now, I want to mention to you that, okay, China and Spain has such a bilateral agreement that is a legal basis to enforce court judgments, right? But many of the countries, they do not have that. US and China, they don't have such an agreement. Germany and China, they don't. Japan and China, they don't. South Korea and China, they don't. And these are some of the main business partners of China. So again, comparing arbitration and international litigation, in case of international litigation, there is nothing like New York Convention, which makes enforcement easy. When it comes to Chinese foreign disputes, enforcement basis, no convention comes into play. There might be bilateral treaties like between China and Spain, but as I was trying to mention to you, this is of limited practical use in practice, and therefore the enforcement generally poses more problems, right? Again, it's going to be a little bit easier for China and Spain because you are having the treaty that you're already seeing on the screen. But when it comes to, for instance, Germany and China, that will be much more challenging. Okay, one last thing before I open floor for any question that I want to bring to your attention is not specifically about the dispute resolution, but it's about a bigger thing, which is the investment agreement, a large investment agreement negotiated between China and the European Union. So you now know that the European Union has this competence to negotiate such investment treaty for the entire European Union, for all of the member states, because it has exclusive competence to do that. So there is a prospect of this investment agreement between China and EU. Many of the points have already been negotiated. So so-called agreement in principle, making the framework of the investment climate between China and EU, has been reached, but the problem comes with ratification of that. So far, the ratification has not taken place. European Union is hesitant because of certain provisions in the treaty, and also generally about the human rights climax. I'm sure you have heard about human rights abuses in China, and therefore, even though we have some basic issues already negotiated within this treaty, successfully negotiated, the big question will be about ratification and therefore the effectiveness of this agreement. But that goes much beyond the question of just dispute resolution, because this investment agreement is a massive thing that will set the investment environment between European Union and China. So to summarize, you might be having rather simple scenarios like the one I was showing you at the beginning, that the client might even want to just buy something or sell something in China. There might be a multitude of issues that arise in this context. They might be disputes. And my general advice is to think about the problems in advance, and that should make your life a little bit easier. With that being said, I'm very, very happy to receive any questions from your side.
Thank you, Monika, for the presentation. I really enjoy it. I just wanted to come back to enforcement. You talk like the civil code from China and from Spain are really similar. In fact, they have already told me that, but you mentioned that enforcement could be in some ways different. So could you put some examples of that difference that we could find in enforcing?
But Paula, I think we need to talk about two things. When I was saying that Chinese and Spanish law are similar, I meant the law, not the courts, right? As such. So I meant that law on the paper, if you, for instance, would look at company law in Spain and in China, that would be quite similar. So just to give you an example, I think at least in Poland, you have something like supervisory boards. I think you have them also in Spain, in Spanish company law, that you have a board of directors, right, directing the company. And then you have a supervisory board that is approving the key decision and expected to objectively supervise the company. You have something like that also in Chinese company law. But in practice, the supervisory board has a very limited power. Right, so on paper it looks the same, but in practice it has, again, less power, less significance. So I remember when we had a client from Poland, and he was opening we had a client from China, and this client wanted to open a company in Poland, and it was in cooperation with some other Polish business partners. And I remember that we were talking to this client. Look, you have to elect your board members. You have to suggest somebody for the supervisory board, which, as you know, in Spain probably is the same like in Poland, is very important, right? And I remember the Chinese clients telling us, I don't care about that, like, do whatever you want. And we were like, wait a second. And he was like, yeah, I know what is the supervisory board. And I was like, I know it's named the same in both Chinese company law and Polish company law in terms of the language and terminology, but the factual significance and practical use of that was different. So that would be an example. When it comes to the enforcement of law, you can think about many of the examples. When it comes to IP protection, for instance, there is a on paper, there is a good amount of law expected to protect the IP rights, also the IP rights of foreigners. But go to any shop or any bigger mall in China, and you will see hundreds of fake goods, right? So, when I was living in China, I remember, some years ago, some friends coming and saying, hey, Monika, can you bring us to these places where we can buy cheap Converse sneakers? So this is a common knowledge that fake goods are simply existing in China, and there's this kind of social permission for that, if I might say so, that the infringement of, for instance, trademarks, although it's forbidden by law and there is certain punishment for that, in practice is not that much enforced. You might be then asking questions why the law is not then being enforced. The scale of infringement of, for instance, trademarks, infringement of trademarks of both Chinese parties in China and foreign parties in China is massive. So for instance, if you would be walking down the street somewhere in Shanghai, I'm sure you will see at least 2 coffee shops that from 50 meters far will look like Starbucks, and you come closer, it's like, oh no, it's not Starbucks. It's Starbashing or something like that, right? So clearly there's infringement of IP rights. One of the interesting cases that you guys might want to look at is Michael Jordan, super famous in China. So, as soon as Jordan started to be famous in China, there was a Chinese company. I'm going to show you the trademark, and you will tell me whether it looks it looks tally to you. Just a second, let me open that. I think that will be quite a good example to present to you what I'm talking about. Okay, Michael Jordan. I'm sure you know Michael, right? Okay, so let's find the trademark that I meant to show you. There was a long dispute, many years, between Michael Jordan and the company Chaodan. Okay, Chaodan, which is a Chinese name of Michael Jordan, by the way, because you know that, for instance, when you have a foreign name of something, then you also have a Chinese name, right? So, for example, Barack Obama, you don't write it in Chinese language, Obamea. You say it in Chinese characters, Obama, and that would be 3 Chinese characters. The same, Starbucks, it's not Starbucks in Chinese language version. Every Chinese person says, 我们去星巴克. It means, if you speak Chinese language, 星巴克, it exactly means a bucket full of stars, right? So let me show you the screen, and you guys tell me whether it looks confusing, at least to you. Can you see that? So I see we have at least one gentleman in the class. I don't know if you are interested in basketball, but this is Air Jordan, right? The brand developed with Michael Jordan with Nike, right? And this is Chaodan, Chinese brand, building and benefiting from Michael Jordan and from the popularity of Michael Jordan in China. Basketball is super popular in China. In Europe, we are more crazy about football. In China, they are more crazy about basketball. So the long story short, for years, Michael Jordan was battling the abuse of his name and trademark of Air, right? It's like, I think it's called Air Jordan, and only recently won after so many years. But meanwhile, Chaodan made so much money out of kind of conscious abuse of Michael Jordan's name and the trademark of Air Jordan. So if you would be going to any court balls in China, and this is quite normal that you have, for instance, university, and there is a basketball field attached to that, you will see plenty of players wearing Chaodan shoes and using Chaodan equipment. And guess what? I think, if I'm not mistaken, at least when I was living in China, the dispute was already in favor of Michael Jordan, but still Chaodan shops were opened and existing. That's what I mean, Paula, difference in enforcement of rights. Law on paper vis-a-vis reality. But frankly, this enforcement issues, they exist also in different countries. I was telling some of you probably last time when we had the class, at least those private international law, that on paper, for instance, you don't have to legalize the documents coming from the European Union. In practice, you have to, right? Like, this is my example in Spain. So let's just see the enforcement of law as sometimes a general issue. More questions?
Sorry, I joined a bit late, so I sadly missed a large part of the presentation, but I wanted to ask, touch on 2 things. First, I'm I don't have that much experience with that, but I heard that for some Chinese companies, it's they are obliged at a certain size to actually get a party member or sell into the, I don't know, in the maybe board of supervision, or actually in the board, in the official board, like this. And my second question was that I think it was 2017 that I read that joint ventures from the outside of, if I invest in China, as a European company, if I want to do this, for example, create a new plant to produce, I don't know, BMWs, it has to be a joint venture. If I invest,
you have to have a Chinese partner.
Yes, exactly. I want to touch on this, if you could elaborate on this a bit.
Sure. 2 great questions. When it comes to the Communist Party members, yes, you have them. there is pretty much a compound of Communist Party membership anywhere where you look around. So for instance, but that was rather more recently at my university. My Chinese colleagues, where I'm teaching, my Chinese colleagues, like once every 2 weeks, they had to go for the party meetings. Between us, oftentimes they're like, oh my God, they are just so boring, but they had to do that. But I want you to be aware that membership in the Chinese Communist Party is something much more common than the membership in the political parties, for instance, in Europe, right? I'm not sure if you guys are involved in any political party as a member. I'm not. It's not common. I don't think I have many friends who are, right? Whereas in China, it's quite common. And I oftentimes ask my Chinese students, but like, you know, poking them a little bit, like, but are you a member because you so much believe in communist values? And they're like, no, I mean, like, you know, for my career, it's just better because, you know, it opens you simply more doors. So many of them are on paper members of the Communist Party because it makes your life easier. But de facto don't really care about it, right? For the second, but yes, there is an expectation, and you will have this obligations to have certain Communist Party representation also in the companies, universities, companies, pretty much anywhere you have that. So just to give you even funnier example, now it's not funny anymore to me. I mean, like it became part of reality. But I remember when I came to office once, and there were like, probably you have seen this big book, like Thoughts of Xi Jinping. And they were lying on the table, and you know, like, and my colleagues had to get one. They were not, I mean, I'm not sure if they were obliged to read it, but everybody had to get a copy. And I asked, if can I get one? And they're like, no, it's only for Communist Party members, right? Anyway, so yes, to answer your question first, yes, then obviously you'll be having questions about what's the practical significance of this Communist Party compound. Certainly, you might get a bit of hold for certain decisions that are against perhaps party vision. So yes, that's important, that's relevant. Second, for joint ventures. So see, there, as I said, like at the beginning, I opened, George, with flagging the issue that you might be having the requirement under Chinese law that in certain sectors, in order to act as a foreigner, you need a Chinese partner, right? That was exactly the case for years for automotive industry, especially BMW, Audi, Volkswagen. If you wanted, as a German, let's say Volkswagen, if you wanted to do business in China, you had to cooperate and form a joint venture with Chinese. Generally, now it goes more in the direction of relaxing that requirement with a simple reason. When China introduced this obligation for joint venture, it's because it wanted to learn technology, get the knowledge, get the insights to the industry. You know, now when it comes, for instance, to building the cars, automotive sectors, they got the knowledge, they got the experience, they know how to do that. So you don't really need that anymore, right? But yes, there are still certain sectors that if you want to do business, you can do that. I mean, you can do that, but you need a Chinese partner. But there is also certain area of business where you cannot do a thing when you are a foreigner. That would be two interesting cases. That would be, for instance, media, right? As a foreigner, you really can't do much in media sector. And Chinese traditional medicine. So Chinese keep it reserved only for Chinese with this underlying logic. We know best what's Chinese traditional medicines, and this is our kind of heritage, and therefore foreigners cannot open business in this area in China. Good questions. More questions?
I had a question.
Sure.
Before you said that Spanish companies that were doing business with Chinese ones tried to incorporate arbitration agreements into their contracts, and I was wondering which preference do the Chinese company have?
Great question. Great question, Laura. Generally, now the Chinese party have the preference for Chinese arbitration institutions. And this is especially relevant, you know, where they have more of bargaining power, where they have more power to push, right? So oftentimes they'll be voting for CTAC, but this is not completely a stupid idea from the foreign perspective as well, because as I was telling you, these institutions, especially CTAC, Beijing Arbitration Commission, they have handled already quite a number of international cases. If you look into the statistics, they do quite a lot. So if you ask me about Chinese preferences, that would be Chinese arbitration institutions, and this leading international institutions, I mean, Chinese institutions, but international character are generally also preferred in that context. Now, The other option, Laura, would be either Hong Kong institution or Singapore. So Hong Kong and Singapore, they are oftentimes perceived as kind of understanding Chinese culture, as kind of a connector to Asia. So my experience now, in the past, it was also like, for instance, Sweden and Switzerland were used as an alternative. Now I feel it's less and less. Also, if you look into the statistics, how many China-related cases these institutions handled, and it's to the benefit of Hong Kong and Singapore. So in practice, it's either Chinese institution or Singapore and Hong Kong. But as I said, remember that arbitration is pretty much private dispute resolution method. You can name your arbitrator. Obviously, it's supposed to be neutral, not your advocate, but you have an impact on who will decide your case. And then these are institutions who care about reputation. So if the institutions like CTAC and Beijing Arbitration Commission, they would have a bad reputation, the parties would simply not choose them. And therefore, my experience, and I've worked with both Beijing Arbitration Commission and CTAC, is that really they strive at least to be neutral and professional. And you can do everything in front of CTAC and Beijing Arbitration Commission in English or in Spanish if, for instance, Chinese party would accept. More questions?
I had one more if like nobody else has one. Like, I have one question regarding like this term, like she announced like this thing a year ago was common prosperity. And I was wondering because the idea, what I thought behind this is like that individuals and companies and corporate businesses basically distribute money on their own, like to the incentive to get those people to do this. But is there also like a impact on law, like to get to this common prosperity? Like, is there anything moving in the law, like in the codified law in China?
So a couple of thoughts. To me, understanding this threat of Xi Jinping, one of the major issues that I hear him addressing and actually working in this direction and advocating for is lifting the Chinese nation out of poverty. I feel he's obviously less concerned about private initiatives, private business, but I want you to be mindful of one thing. It's a communist country, but the private initiative, private business, it's at its best. There's more capitalism in China than anywhere in the world, practically, right? Look, so George, what is, for instance, done under Xi Jinping? There are strong social campaigns, for instance, not to show off how rich you are, to push to support certain charity initiatives and things like that. So, for instance, under Xi Jinping, there are strong policies to avoid this kind of, to give you an interesting example, lavish buildings, lavish constructions. If you look at Shanghai, why Shanghai is such an attractive city? Because it has amazing architecture, landscape, right? Now, Xi Jinping said that everything should be more utilitarian, useful, and we should not be spending money on things like lavish lifestyle, lavish dinners, lavish buildings, and things like that. And there should be a more equal distribution of profits in the society in order to benefit those poorest as well.
Thank you.
I may have another question, if I may. You talk about the EU-China Comprehensive Agreement on Investment and the fact that they are still like it's on hold because that's the part of human rights and environmental rights. Do you think that they would finally sign something? Because like China has like the Uyghurs, Muslim ethnia, and they are being like, I don't know how to say it, but it's not so friendly human rights. Also the environmental one, like China is using a lot of carbon for the industry. What do you think? It would be like actually signed, or how to monitor that also? Because you may sign it and say, yes, okay, we're going to do it, but China may say, okay, and they will continue to do it.
Okay, so Paula, this is a very interesting question. I want to start from the end. When you talk about, for instance, environmental issues, I think there's a bit of misconception around that. Yes, China is still polluting quite a bit, but I want you to see one thing. especially in the past, because now China stopped being this cheap producer, for instance, because labor is much more expensive than it used to be 10, 20 years ago, right? Therefore, producing in China is not that cheap anymore. If you look at where your clothes are now being produced, it's more Bangladesh, Indonesia, Cambodia, right? Not everything is now made in China simply because producing in China became more expensive. But Paula, for years, why actually China was having this production and why China was having this pollution, because this was based on the orders coming from all around the world, including Europe. So I feel number one thing is like, I feel there's a bit of hypocrisy to say China is polluting, but we as European consumers, we also don't want to pay more, right, for the goods. But this is a little bit more of the past. Now, China is having a massive shift toward green energy. You can see this is the fact. This is the scientific evidence. I don't know, guys, if you are aware, but China is producing much more of clean energy than US. I think this is oftentimes missed in the discussion, but when it comes to the production of green energy, clean energy, China is producing much more than US, right? So this is being developed. This is highly in the agenda of China for its own benefits. That look, when I started to live in Beijing in 2011, pollution was massive. When I was working in the law firm, obviously it was one of those nice buildings with nice view. When there was a clean day, everybody was taking phones and taking photos. Now, when I was living in 2019, that was normal. The air quality has significantly improved. It has improved because the green policies in China have been really pushed forward. So China has this strong drive for the environment. Now, when it comes to human rights, I think there is a reserve trend. I think China goes back with the human rights. You mentioned Xinjiang and Uyghurs. There's obviously also a question of Hong Kong. There is general question of censorship and freedom of speech, which me also in the academic area, I observe it deteriorating. And that certainly will be a remaining concern. I think for now, Paula, this is the biggest issue, human rights for forced labor and things like that in China. So whether to give a big frame and answer your question, whether the agreement will be ratified, I would understand. My understanding is that at some point it will be, because as I said, agreement in principle, meaning the most important things, they have been signed already. Let me send you a link. I think it's by the European Commission, I believe, yes, where you can read about this comprehensive agreement on investment. What is in there? So I'm sending it in chat if anybody is interested. My commercial sense is that let me put it that way. My sense is that the commercial drives and needs will eventually win. How China will address its human rights, here I'm more skeptical. That's my sober, realistic check. I think, look, economically seeing at what will happen now in Europe, what is already happening because of the war in Ukraine, will be sanctions involved vis-a-vis Russia, which, Europe will also pay certain price for, probably will push for a certain agreement in China, probably will be an additional agreement to reach some compromise in this investment agreement with China. And that at some point will be ratified. So that is my vision, that yes, given the fact that the negotiations went so far and, everybody was aware of human rights when the agreement in principle was negotiated. So now it's the question of ratification. And I would assume that at some point, yes, it will be ratified and therefore will come into play. Also, because we need some legal framework for business with China, for the investment with China. You know that now it's the EU negotiating that. Spain cannot do that. Poland cannot do that. And, we will not avoid the investment, trade and business with China. So yes, that would be my answer.
Thank you.
Anybody?
By the monitoring part, like if it's ratified, like there's some kind of monitoring, like if China do not comply with that, like to check.
You will be having some general mechanisms to resolve the disputes, right? It will be more relevant for the disputes between state and investors, most likely. Like I gave you the examples of the Chinese company building the highways. what will be the screening, whether there will be a screening mechanism between two parties when it comes specifically, for instance, to the question of violating human rights. I'm not sure, but in any way, I would have doubts if this mechanism would exist, how effective it will be to finish the potential violations in China, right?
Yeah.
So
Complicated. Yeah.
yeah.
Okay, thank you for your answers. I don't know if anyone has more, but I think that time has like passed. And yeah, just like thank you again for your time and presenting the issue. It was a really interesting one, and I really enjoyed it, truly.
Thank you. Thank you. If you would be having any questions, any further issues, stay in touch. Previous semester, I was teaching Chinese law and culture course in ESADE, so stay in touch in case we would be having that in the future. And yeah, I even my final message to you would be, I think the role to get interested in China is even more important now because it becomes more and more problematic. But that means that more and more experts in Europe are needed to understand China, to understand the law, to understand the culture, to understand the other side for the effective dialogue, right? If we want to engage in a dialogue with China, then we need to understand it. Like, just to give you an example, you know, when I was already working at my university for 8 years or so. And then, you know, sometimes I was kind of pushed, like, can you go and talk because you would know how to talk to Chinese? So other foreigners were like, would you just go and ask on our behalf? Because, you know, you already know how to talk to Chinese people. And therefore, I will encourage you to think about China-related career prospects, especially in these difficult times, especially when the specialists here in Europe are needed. So best of luck. I hope you could have learned something in this class, and I encourage any contact in the future.
Thank you very
Thank you,
much.
Monika.
Thank you.
Okay.
Have a good weekend. Bye-bye.
Bye.